For motion item 1.
May it please your lordship, my lords.
Yes,
This 40 is the impugned
this is an impugned, this is a contested matter.
contested matter. Chair received.
So today it will not be possible to dispose of. We'll issue notice and take down. Heard Mr. A. D.R. Nayak, counsel for the petitioner, also heard Ms. A. Verma, learned standing counsel, Home Department or some.
LCR, I see.
LCR has come.
LCR is there, lordship.
Negative, Ms. S. Borwal, RNCBC, appearing for the Union of India. Ms. A. Verma, learned standing counsel, Home Department, Assam, and Mr. Commodore and Mr. A. Ali, learned standing counsel, ECI. Full stop. Next, in terms of the order dated 6/5/2024 passed by this court, the LCR has been received from the Coroner's Tribunal. We have perused the same. After going through the LCR, it appears that this matter would call for deeper hearing. As such, issue notice returnable 6 weeks. Since the respondents are already represented, all respondents are represented.
Lordship.
What about NRC?
NRC, your lordship. We have subject copy to all, your lordship. We have taken steps all respondents, your lordship.
Since the respond numbers 1 to 5 are already represented, we formal notices.
Your lordship will verify, your lordship. With that.
Extra copies of the petition be furnished to the Learned Department Council.
By postal.
Stop.
tips.
Petitioner takes steps for service of notice upon respond number 6 by register within a week from today. Let this matter be listed again after 6 weeks. Along with the LCR.
Obliged.
Lordship, I would like to beg your pardon, please. I was here only for a second. I went out. I just like to mention a matter. I beg your pardon. I was here. I just went out for a second. I like to mention a matter, WPC 3171 of 24, to be taken up as the last item. There is an urgency. No, it's not listed, but it was listed a week before, Lordship. It may be taken as motion
Today,
today.
today it will not.
Because of there was a problem in the synopsis, Lordship.
Indeed,
In the problem in the synopsis, it was listed a week before. No appropriate order could be passed.
today we can't have a list. Without a list, it cannot be taken. You should have mentioned it yesterday. We would have got it.
Lordship, I came yesterday also. I was wait for some seconds.
Yes, next matter. Please.
Obliged.
May please your lordship. Lordship, contested matter. LCR was called for, my lord. LCR received.
LCR has been received.
Yes, my lord.
So all these cases are following the same, what do you
Same
do with
order,
the
Lordship.
LCR? You have to pass a contested order.
My lord, in this case, I am not a interim, my lord. The honorable court,
Interim, lordship, in this matter, lordship had said that interim would be considered only after examining the LCR.
after receiving the LCR, my lord. The LCR received-
Argo? Argo for interim? Argo for interim?
Yes, my lord. Yes, done, my lord. May please, in this case, lordship, the
What is the date of the order?
date of the order, my lord, 21/11/2023. 11/23, the petitioner submit the voter list of 1965, father, mother. The petitioner father name is Jabbar Ali.
And where is the order, impugned order?
Impugn order, my lord, page 78, my lord. My lord, impugn opinion, my lord, is puzzling opinion, my lord. Most probably, my lord, kindly come to the page 86. Opinion part, my lord.
Lordship, this matter may be posted immediately after reopening, lordship. Because it will take some time. We cannot just go through it, lordship.
If there is an order that interim will be considered, we
yes,
have to
Lordship.
consider it today.
Yes.
There is an order, is it not? Is there an order saying that interim, prayer for interim order?
No, verbally saying, honorable, verbally saying, my lord.
LCR is now notice, normally questions are notice. Without notice, LCR are with notice is very interim. So এটা নোটিশ ইস্যু মানে এলসিআর এর সাথে
One of the interim land.
Interim, I mean, big koi logo.
Alright, you argue for interim.
My lord, page 86, my lord. And come on opinion part, last portion, my lord. In my opinion, the OP could not discharge the burden of providing that her parents entered to rest in Assam during the period from 1975 to 1989. After their first entry into the sometime before 1/1/1966, and therefore they would be regularized as they deemed citizens of India under Section 6A Clause 2 Citizenship Act, or that she was born in Assam or India during the relevant period, or she herself come to the state along with her parents at the time of the first entry, and therefore she was a citizen of India either by birth or by residency under Section 36/6A Clause 2 Citizenship Act. My lord, herein said that she was a citizen of India. Later on, my lord, order part reference has been answered in affirmative. My lord, to submit all the document, my father, my brother, entire family member, and also my link with my father. That is the land document and a legal heir document, my lord, of my deceased father, my lord.
So what are you arguing actually? I have not understood it. Please. What is your argument?
My lord,
This page 86, by referring to it, what is your argument?
reference to the here said that therefore she was a citizen of India,
Ah,
either by birth or by residency under Section 6/6A Clause 2 Citizenship Act. And order, my lord, it should be declared a foreigner.
not at all. The court says that
My lord,
the tribunal says she has not been able to discharge the burden of proving
Yes.
either this or
Yes.
that or this or
yes,
that.
yes.
So
But
she has not been able to
we
discharge.
submit all the document of my father.
That is another matter. Then
Yes.
why are you showing this?
My lord, kindly come to the page 26, my lord. Bhuta list of 1965.
First, why did you take us to page 86 then? To show what? No, you are not prepared. You should notice both on main and interim. Heard Mr. F.A. Hassan, counsel for the petitioner. Also heard Miss A. Verma, learned serial young Miss S. Burwal, CPC, so and so, so and so. Government, nobody is appearing.
My lord,
You are Mr. इसके आगे का जी आसम ऊपर to दिखो. Who are present on behalf of the respective respondents. LCR as called for by this court has been received. Petitioner submits that an interim order be passed in this case, protecting the interest of the petitioner. However, after hearing the learned counsel for the petitioner, we are of the view that the matter would require further deliberation. As such, should motion returnable on 31st of July 29th of July 2024. This is the respondents numbers 1 to 1, 2, 3, and 5 and 6 are already represented by the Learned Standing Council. No formal notice is required to send to the said respondents. Extra copies of the writ petition are furnished to the Learned Department Council. Petitioner to take steps for service of notice upon respond number 4 by registered post with AD. This is further deliberation after service of notice upon the respond number 4. I shall continue so and so. Registered post with AD on respond number. Heard on the prayer of interim relief, issue notice on the interim prayer returnable on 29/7/2024. Registry to list this matter along with the LCR on 29/7.
obliged.
Lordship, I beg you, pardon you, Lordship. Item number 1, your Lordship. So interim is not there, your Lordship. Because LCR has come, your lordship. The interim is not there.
Go to the
Lordship, this is a two
part of the
thousand
prayer of interim
eighteen,
relief.
2018.
Lordship, the
Say
opinion is
prayer
of
be
two
considered
thousand
the
eighteen.
Will be considered on the returnable date. After you have finished arguing the matter, you can now start arguing for interim relief. You can't. You understand the court proceedings, there is some semblance of decorum here. Yes,
Lordship.
all right.
Yes.
Interim and returnable date.
Hello. This is the page 29, annexure 4, my lord, opinion. Yeah.
Yes.
Page 31 is the relevant part, my lord. May I read it?
This is a contested matter.
Yes.
The opinion is of 2022.
Yes, my lord.
We'll issue notice at this stage and call for the LCA.
May be protected, my lord.
Sorry,
May be protected.
you are protected by the state.
Yes.
Last 2 years, they have protected you. They will protect you for another 6 weeks. Is it not, Ms. Verma? All the protection is coming from the state.
Yes,
The
Lordship.
court doesn't have to do anything. Three, you write, had Mr. A.Y. Chaudhary, and counsel appearing for the petitioner. This petition is directed against the opinion dated 2012-2022, passed by the learned member, Foreigners Tribunal number 2, Silchar, Kacha, Asli. In connection with the FT case number 1552/2018. Mr. A.Y. Chaudhary submits that this is a contested matter, but the learned tribunal has failed to appreciate the evidence in the correct perspective, thus leading to the interim order declaring that the petitioner was a foreigner for the post-1971 strip. After going through the materials available on record, we are of the view that the matter will call for further examination. Issue notice returnable in 6 weeks. Since Ms. S. Borwal and CGC has appeared and accepted notice for respondent number 1. Ms. A. Verma, learned standing counsel for the department, Government of Assam for respondent numbers 2, 5, 6, and 8. Mr. A. Ali, learned SCECI for respondent number 4. And who is for election officer? What election officer? Huh? Achha, A. Ali for 4 and 9. As such, service of notice upon respondent numbers 1, 2, 3. 1, 2, and 4 to 9 are deemed to be complete. Extra copies of the petition be furnished to the Learned Department Council. Petitioner to take steps for service of notice upon respondent number 3 by registered post with AG within a week from today. Call for the records. Heard on the prayer of interim relief. The said prayer will be considered on the returnable date.
Oblige. May I please, your lordships? Lordship, this is a contested matter, your lordships. Impugning order starts from page number 26, your lordships.
So should we issue notice and call for the records?
Yes, Lordship.
Contested matter.
Lordship, I may be protected, your lordships.
What is the date of the opinion?
23, Lordship, 31.
31/8/2023, your lordships.
So you have got protection since the last 8 months, 7 months.
Lordship, police is behind me, lordships.
We'll consider it. We'll give a fixed date. You manage to stay
So
afloat.
my
for-
humble submission is my home was destroyed due to flood in the last flood occasion, and police is behind me, lordships.
Since when?
Uh,
Police is behind you since when? Where is the statement?
when my home was destroyed,
Hmm.
then I came before the deputy commissioner of Darong.
Hmm.
Thereafter, they got to know that I'm a declared foreigner. Thereafter, police is behind me, your lordships. And my father was deposed before the tribunal that he is my son, your lordship. He's page number 81, your lordships. My father is deposed.
You wait till 29th. Heard Mr.
S.A. Borwe, your lordship.
S.A. Borwell, I counsel for the petitioner. This petition is directed against the order dated 31/8/2023 passed by the learned member Foreigners Tribunal, Durham, in connection with FT case number 6798 of 2011, declaring the petitioner as an illegal migrant who had entered India from specified territory subsequent to 25/3/1971. Full stop. Mr. Borbia submits that this is a contested matter, um, and uh, and the learned tribunal has failed to appreciate the evidence in the correct perspective. The petitioner's counsel has also prayed for an interim order protecting the interest of his client by submitting that the police is looking for the petitioner. After going through the materials available on record, we are of the view that perusal of the LCR will be necessary before passing any effective order in this case. As such, issue notice returnable on 29/7/2023. Since so and so, मिला ना वो, नहीं जाने. State coordinator steps by registered post with AD within a week from today. Call for the LCR. Pardon the prayer of interim relief. The said prayer will be considered on the returnable date. List this matter again on 29/7/2024 as a fixed item.
Deeply obliged, Lordship.
Me, it pleases the lordships. Lordship opinion is at page 35.
It is 35.
Contested matter, yes, lordship.
What is the date of the opinion?
Date of the opinion is 14/2/2024.
This is a fresh matter. We'll issue notice or keep it for motion. It's all the same. Then again, next day, another date.
Notice LCR so that one step is ahead.
Hard
Lordship.
miss. Hard miss H. Betala, learned counsel appearing for the petitioner. This petition is directed against the order dated.
Returnable date of the revoke.
Lordship, I may be allowed to file amended cause title because respondent number 6, we need to correct it as DCP border. We have written SP border, but it should be DCP border.
Order dated 14/2/2024, passed by the learned member, Foreigners Tribunal number 1, Kamrup bracket M, in connection with FT bracket D full stop V bracket close. Case number 1270/2018, declaring the petitioner to be a foreigner of post 1971 strip. Ms. Betala submits that this is a contested matter, but despite adducing sufficient evidence on behalf of the petitioner stroke proceeding, his case has not been considered in the correct perspective by the learned tribunal. As such, the interim order is vitiated by non-application of mine. First of all, after perusing the materials on record, we are of the view that the matter calls for further examination. Issue notice of motion returnable on 12th of August 2024. Since so and so, black code was NRC to register post AD. NRC is there? Yes, number
Yes.
4. NRC is number 4. Call for the LCR. Heard in the prayer of having regard to the facts and circumstances of the case, it is hereby provided that in the event of arrest, the petitioner shall be released on bail. Petitioner shall be allowed to go on bail on furnishing a bond for rupees 5,000, subject further to the condition that within 4 weeks from today, he appears before the DCP border.
Yes,
DCP border,
DCP border.
Kamrup, for recording his fingerprints and iris of the eyeballs. On the oral submission of Ms. Betala, the petitioner is permitted to submit an amended cause title, correcting the
Respondent number 6.
designation of the respondent number 6 by replacing him by DCP border Kamrup Metropolitan.
Item 6.
May I please your lordship?
Yes.
My lord, I contested the matter before the tribunal and submitted documents, my
What
lord.
is the date of the order?
17/5/2019.
We'll issue notice, that's all. But Mr. So-and-so, as Salim Lani counsel for the petitioner, this writ petition is preferred against the order dated 17. No, opinion is 16 to 2000.
16 my lord.
Why are you saying?
But lordship, here it is 17. I checked it up right now. Which one? This is your matter, Anurara.
Yes.
But here it's in this one, page
16 to 2024, is it not?
66, lordship, page 66. I just checked it. It's
Where is, which page is the opinion?
Yes, 72 my lord.
seven. I think our paginations are not matching, lordship. My page 72 is something else. And here impugned order is dated 17/5/2019. Just check.
Index.
No, I don't. ये तो कैसे?
No.
What has happened?
This is some other case, my lord.
Some other case.
Anwara Khatun, this one is also Anwara Khatun, lordship. 2446
Name of the petitioner is similar.
district.
District
This is
Metro.
Kamrup, and I am holding a copy which is Borpeta.
We understand the tribunal is being confused, but if the councils are also
No,
confused,
lordship, that's
The
same
similarity-
name, lordship, Anwara Khatun and Anwara. This is also, I'm holding a same copy.
anyway,
Extremely sorry,
it
lordship.
appears that this order is of 16 to 2024. It's a recent order.
Recent order. Yes,
Not similar.
lordship.
So
It's
16
wrong
to
file.
2024 passed by the learned member, Furnace Tribunal, Kamrup M in bracket close third, whereby the petitioner was declared to be a foreigner of post 1971 stream. Mr. Alim submits that this is a contested matter. However, despite adducing sufficient evidence so as to establish the citizenship claim of the petitioner, the learned tribunal has failed to appreciate such evidence in the correct perspective. As such, it is submitted that the impugned order is vitiated by complete non-application of mine. After perusing the materials on record, we are of the view that the matter calls for the examination. Issue notice for motion return to the 9th of August 2023. Since Ms. S. Barua, Lanet CBC, has appeared and accepted notice for respondent number 1. Ms. A. Verma, Lanet SC Home Department, Government of Assam, for respondent numbers 2 and for respondent number 2, Mr. Hazarika, S. Hazarika, is it? H. K. Hazarika, Lanet G. Assam, for respondent numbers 3 and 4. And Mr. H. Ali, SCECI for respondent number 5. Service of notice upon respondent numbers 1 to 5 is deemed to be complete in this case. Extra copies of the writ petition be furnished to the Learned Department Council, requisite in numbers so as to enable them to obtain instruction. Petitioner to take steps for service of notice upon respondent number 6. Call for the LCF. Hard on the prayer of interim having regard to the facts and circumstances of the case. It is hereby provided that in the event of arrest, the petitioner shall be allowed to go on bail on furnishing a bond of rupees 5,000, subject further to the condition that she appears before the you have not even implemented the police.
My lord?
Police is not even implemented.
No, my lord.
This is what Kamrup Metro, DCP border Kamrup M.
Not meeting.
Within 4 weeks from today for recording her biometrics and iris of the eye.
The respondent 3 is the Deputy Commissioner of Police, lordship.
Actually, respond number 3.
Yes, lordship.
Then A. Verma will be 2 and 3. And Hazarika for 4 only. Appear before the respond number 3 for recording her biometrics and iris of eyes.
I am obliged, my lord.
Lordship, item 7 may be taken as the last item. Mr. Pine would address the court. Item 8. Item would get to the other. Let go, Edmund.
Yes,
May I please, Your Lordship?
yes, please.
My lord, the date of opinion on 10/5/2023, my lord.
Hmm.
And my lord, the petitioner, my lord, exhibited voter list of 1956-71 of her parents.
1 minute. What is the date of opinion?
10/5/2023. Opinion at page 81, my lord.
Hmm. Yes, what is your case?
My lord, my case is that, my lord, the petitioner exhibited voter list of 1966-71 of her parents. And her voter list, my lord, 1989. But these documents were not, my lord, billing.
How the tribunal is dealt with this?
My lord, the opinion at page 81, my lord. The
Let's come to the relevant part.
relevant part at page, my lord, 87, my lord. Judgment.
Page 87.
Yes, my lord.
Yes.
My lord, para 1, as per terms of the reference, OP is the daughter of Kabir Khan and wife of Habibur Rahman, resident of village Dharmapur, PS Sorbuk, district Borpeta, which are the facts admitted. From exhibit 1 and 2, it has been ascertained that OP's father, Kabir Khan, and mother, Nobiron Nessa, and others as found in those two exhibits, came to Assam from the specified territory before the cut-off date of 1966 and illegally registered their names in the electoral rolls of 1966 and 1971 from a village in the state. This is, my lord, 66 and 71 voter list.
But the tribunal says your parents have come before the cutoff date, but they again went back for 18 years. They were again
My lord, that
back
is,
to. Huh?
but the documents does not show.
Continuous stay is not proved, Lordship.
Sorry?
Continuous stay in the state of Assam is not there.
The documents are there.
It's a prima facie case. We'll examine it. It's a presumption. It's a presumption. All right, I heard Mr. S. A. Amel, counsel for the petitioner, also heard Ms. A. Verma, Lanes, SC, Home Department, Assam, SA, SH, Zarika, and G. Assam, Mr. Burwal, Lanes, CGC, and Mr. Ali, Lanes, SCECI, appearing for the respondents. In terms of the order dated 22/5/2024 passed by this court, the LCR has been received. We pay the same. It appears that the learned tribunal had recorded a fine. It appears from the impugned order dated 10/5/2023 that the learned tribunal had recorded a finding that the parents of the petitioner were in India before the cutoff date of 1966, but due to absence of names of those persons in the electoral roll for a period in between, it was assumed that they had left the country and had returned after 18 years. Full stop. Such assumption is drawn on the basis of certain documents available on record. However, Mr. So-and-so submits that the assumptions are erroneous inasmuch as there is nothing to prove the absence of the petitioner's parents from the territory of India. After going through the materials on record, we are of the view that the matter calls for deeper examination. So issue notice of motion returnable in 6 weeks. Since can you you can do it, no? So. Then NRC coordinator registered post number 4, hard number 4 by registered post with AD. Hard on the prayer of interim relief having regard to the facts and circumstances of the case, you can see hereby provided that in the event of arrest, the petitioner shall be allowed to go on bail and furnish a bond of rupees 5,000 Subject further to the condition that within 4 weeks from today, the petitioner appears before the
SP border
Superintendent Police Border Borpeta for recording and biometrics iris of the eyeball. List this case again along with the LCR.
Oblige me.
May I please, Your Lordship? Lordship, it's a contested case, Lordship. The opinion is of 1/124, Lordship. Lordship will find the opinion of page 68, Lordship.
We'll call for the record at motion stage and then see what happens. Mr. M. Ahmed, counsel for the petition. So and so, so and so, so and so. Mr. Ahmed submits that this is a contested matter and despite sufficient evidence adduced on behalf of the petitioner to establish a citizenship, the learned tribunal has failed to consider the same in the proper perspective. First of all, appreciation of the above submission made by the petitioner's counsel would require perusal of the LCR. Such registry to requisition the LCR from the foreigners tribunal. LCR in connection with FT case number 2005 of the 2017 from the foreigners tribunal number 11, Borpeta at Sorbu. Let this matter be listed again after receipt of LCR. As an interim measure, we have provided that in the event of arrest, the petitioner shall be allowed to go on bail, by furnishing a bond of 5,000, subject further to the condition that she appears before the superintendent of police Borpeta
Yes.
within 4 weeks from today for recording her biometrics and iris of eyes.
Oh, yes.
Supplementary list for motion item 14.
May I please, Your Lordship, my lord. My lord, impugn order at page 104, my lord, annexure 18, my lord. This opinion was rendered on 21st of February, my lord, 2024, this year, my lord. Page 104, my lord. Annexure 18, my lord. 21st of February, 2024, my lord. The voter list.
District.
Morrigan. Actually, my lord, the reference was initiated against the husband and the notice was issued against the husband as well as the petitioner, who is the wife of the particular person and along with other family members, my lord. Accordingly, they had contested the case, my lord, and all of them were declared to be foreigner, my lord. Later on, my lord, the husband and the present petitioner, my lord, both of them, my lord, had appeared before this honorable court. And the earlier opinion was, my lord, challenged before this honorable court, my lord. And accordingly, the matter was remanded back to the concerned tribunal, my lord, for a fresh consideration, my lord. And the petitioner had appeared before the concerned tribunal and she could, my lord, submit her WS, my lord, only. And she could only submit the Xerox copies of some of the voter list. And the vital document, my lord, which was earlier exhibited, my lord, as exhibit BB, my lord. That is the only linkage document along with her father, land document, my lord. She had inherited land from her father, my lord. That could not be exhibited. And she was not given sufficient time, my lord. Actually, she was declared. What is are you saying this is an expert opinion? Not expert, my lord. Then inter-party, my lord. Then contested. What is wrong with the opinion? My lord, nothing was considered, my lord. The reference was against the husband, my lord. Yes. Only, my lord. Yes. May I take your lordship, my lord, to page, my lord. 54 page, my lord. Annexure 8, my lord. No, can you please point out from the order, impugn order? My lord. Show us what is wrong. Yes, ma'am. Yes, ma'am. Page number 110, my lord. Second paragraph. So your reference was against the husband and the petitioner also? No, my lord. The reference was against only husband, my lord. Not against the petitioner. But the notice was issued, my lord, against the husband as well as against the present petitioner, who is the wife of that husband and along with other family members. Many cases, my lord, in notices are issued, my lord, against the. But her name is mentioned in the order. Her name is mentioned in the order, but my lord, the notice and the reference and inquiry, my lord, was conducted against the husband only, my lord. At this stage, my lord, I'm praying for interim protection only.
LCR may be called for, this court may examine the notice and the inquiry report and then
Yes,
We'll then issue notice because he's saying the reference is only against the husband.
Yes,
Petitioner, but she has also been declared a foreigner.
yes.
If the reference is only against the
So
husband.
the records of both the husband and wife ought to be here so for examination, lordship.
is a certificate. copy,
Because
sir.
he's referring to the husband's reference and the opinion is against the wife.
Not against the wife only, my lord, along with all the my lord.
So lordship, since it's a complicated matter, let the records come before this court, then lordship can examine the matter.
We'll issue notice then.
Yes,
also.
My
lordship.
lord will kindly consider my interim trial.
Right, you take. that.
Lordship,
Not miss-
on the returnable date, lordship may consider the interim lord.
No, my lord, at this stage, my lord, because I believe
I'm just,
this is a clear case, my lord.
You are not
Then we-
serious about it. You are just saying it. Is that?
I'm just saying it, lordship. I'm
See,
doing
if
my
this is
duty.
correct, then this is a serious matter. Because the law is well settled that.
If the inquiry is against one
Inquiry
person,
has to
then-
be, yes.
yes, lordship,
It's
I
not- It
agree.
has to remain. So it is a matter of law. If the.
Absolutely,
if
lordship.
the original inquiry does not name the petitioner, it has to be set aside. There's nothing else.
Yes,
Yes,
let
ma'am.
the records come, lordship may set it aside if
Alright.
there is any.
All right, I heard Mr. Zaid Ahmad Naik, counsel for the writ petitioner, also heard. How do you give? This writ petition is directed against the opinion rendered by of order dated 27/11/2017 passed by the learned member, Foreigners Tribunal, 5th, Morigaon, Assam, whereby the writ petitioner was declared to be a foreigner
Coming
of
there for
post
100.
1971 stream. Why have you come now, 2017 or?
No, my lord, 2024, my lord. Earlier, my lord, that order was challenged, my lord. Later, my lord, that was my lord, fresh. my lord.
Where is the order present?
Lordship, may I just draw lordship?
Page, my lord, 104.
Page 86. If lordship looks at the previous order by this High Court lordship, my friend only had appeared and page 86, paragraph 7, in respect of the petitioner number 2,
Yes, ma'am.
who is the wife of the petitioner number 1. She would have to prove her citizenship through the linkage with her own father and not through the petitioner number 1. For the purpose, the claim of the petitioner number 2 is also remanded back to the tribunal to enable her to produce any material that she may produce to establish the claim of her citizenship through her own father. This court had directed lordship.
My lord,
That is correct, but was the reference initiated against the petitioner also?
So, we will have to look into the records, lordship, to,
That is what we.
yes.
that has been looked into, my lord, in paragraph 9.
All right, all right. Opinion dated, opinion rendered by order dated 21/2/2024, passed by the London member Foreigners Tribunal, 5th, Morigaon, in connection with FT case number 275/2016, bracket, new number, pertaining to FT, bracket C, bracket 1324/2012, bracket old number, whereby the petitioner was declared to be a foreigner of post 1971 stream. By referring to the impugned order, Mr. Ahmad submits that the proceedings were initiated against the husband of the petitioner, but she has also been declared to be a foreigner without there being any reference ever made against her. So, if the assertion made by the petitioner's counsel is found to be correct, then it may have some relevant bearing on the outcome of this proceeding. However, the state aspect of the matter can be ascertained only after verification of the records. As such, we are inclined to issue notice in this case. Issue notice returnable. You want a firm date, Mr. Verma? A firm date?
Yes, lordship.
21st of August, 2024. Except NRC, Baki to all are there. Steps were registered post on NRC within 3 days from today. All for the records. Register to list this matter again, 21/8/2024 as a fixed item. heard on the prayer of interim relief, having regard to the overall facts and circumstances of the case, we hereby provide that in the event of arrest, the petitioner, namely so-and-so, shall be allowed to go on bail on furnishing a bond of rupees 5,000, subject further to the condition that within 4 weeks from today, she appears before the Superintendent of Police, Beckett Border, Morigaon, for the purpose of recording her biometrics and iris of eyes.
Deeply obliged, madam. Deeply obliged.
Number 9.
Make clear. Lordship, the order impugned from this is at page 19, Lordship. Lordship, it is order dated 18/5/2018. Lordship, the operative part, Lordship, what has happened? A reference
The
was
order is of 18/5/2018.
18, Lordship, what has happened? The earlier council had unfortunately expired. We gave to the new council due to illiteracy and COVID also came. Lordship, I have tried to explain in para 14.
All right, we'll issue notice.
Lordship, I am
If
praying for a.
we'll reject the prayer of interim relief, or we can keep it open for records. You can choose either of the two.
Yes, Lordship, may keep
You
it
want
open.
to choose
Lordship,
option number 1, we'll pass a half a page order.
Lordship,
2018 opinion, no question of interim relief.
Lordship, I have tried to explain in para 14.
You are good.
And Lordship, I'll exercise my, Lordship, may keep it open for the
You
records.
can argue, if you convince us, we'll pass an order. But very little chance after 6 years, interim order till the record comes, you can understand.
Lordship, may like to peruse page 21 for once. That is the analysis of the court. Only one. May I read? Lordship? OP Hamida Khatun disposing herself as DW1 named her father as Abdul Khalek and has exhibited 1965 voter list and the exhibit 1 and 2 is the voter list of 1970 of the purported father Abdul Khalek along with his purported paternal uncle, namely Sultan Mia, Tara Mia of the said voter list of 1970. However, OP Hamida Khatun during her course examination named paternal uncle as Lal Mia and Tara Mia and Sultan Mia, but name of Lal Mia is not to be found. Therefore, it is conclusively presumed that about Abdul Khalek appearing as father in the voter list of 1965 and 1970 is only a projected person. That is only the ground, Lordship. Because I wrongly named my paternal uncle, that is why, Lordship. Therefore, it is not disputed, though burden of proof lies on me. It is the state never rebutted about the authenticity of the voter list. Neither it has questioned the relevance of my father. Moreover, Lordship, some documents, some new documents which I could not procure, Lordship, I did not have. I have annexed to this petition, Lordship. Moreover, Lordship, it is based on presumption only, Lordship. Otherwise, the voter list, Lordship, I have. Lordship, the voter list I have given 1965 and 1970. Abdul Khalek is my father only because I wrongly spelled Lal Mia as my paternal uncle is instead of Lal Mahmud. Lordship, that is only the, and it is only on presumption, Lordship. That is my case, Lordship.
We'll examine it, but we are rejecting the prayer of interim relief. Heard Mr. BP Voral and counsel for the petitioner. This petition is directed. You see, this is how counsel destroy the lawyer case of the client. This is a classic example.
Lordship,
We'll give reasons so that you can go to higher ups if you want.
Lordship, may keep it open. I'll just pray. I'll pray, Lordship.
Huh?
I'll pray to keep it open, Lordship.
No, but you have argued, we have expressed our mind.
Lordship, I exercise my option as a second, but Lordship has permitted me to argue, Lordship.
Heard Mr. BP Voral and counsel for the petitioner. This writ petition is directed against the order dated 18/5/2000, opinion rendered by the learned member Foreigners Tribunal bracket third bracket close Morigaon in connection with case number 194/2015. Declaring the petitioner to be a foreigner of post 1971 street. Mr. Bora submits that the opinion is based on presumptions which are not valid, and the petitioner also could not furnish certain additional documents which are in her favor. Full stop. Contending that the sole ground for presuming for drawing the presumption against the petitioner is on account of misspelling, MIS dash spelling of the father's name of the petitioner, and therefore this is a fit case for interference by the school. First of all, after going through the materials, and we are of the view that perusal of the LCR would be necessary before any further order can be passed. So and so, so and so, so and so are present. ECI? M. Kalita for ECI. Baki will so and so. Register to requisition the LCR. Let this matter be listed again along with the LCR. Therefore, interim relief will be considered at that stage.
Item 16.
No, motion.
Need to, Lordship, he is the husband of Hamida Khatun, item number 50.
Listed, same. case
Same,
number,
but
same.
he is in custody, Lordship.
Sorry,
He is in custody from December 2020.
custody means in where detention? center?
Detention center.
So, list along with item 15, registered requisition, the LCR connected with this case. Let it be listed together.
Yes.
A prayer for interim relief, if any, shall be considered on the returnable relief.
Deeply obliged. Lordship, I am very sorry.
No, but you all should understand one thing. You are coming after 6 years, you want
Yeah, yeah.
straight away interim order.
Yeah. Lordship, I am very sorry.
My learned brother has saved you. Otherwise, I was willing to pass a detailed order, 3-page order rejecting you.
Lordship,
This is not a bargaining market. Yes.
For admission.
Please, your lordship. Your lordship, lordship, kindly the matter be passed over for the day, your lordship.
First of all, for the day. The prayer of learned council.
Lordship rule may be issued since he is already appearing, LCR is there.
Why you want it to be passed over?
Your lordship, actually my senior Begum wants to appear. I am not in this case, but she is not well, your lordship.
Issue rule then.
Issue rule, Lordship.
Mr. Your name, please?
S. Paul, your lordship.
S.
Paul. Paul. Paul.
S. Paul learned council for the petition also had so and so, so and so, so. You put the names, Mr. A. Verma, and Mr. A. Ali, Mr. S. H. Hajarika, government advocate, and L. Barwa. And Siriatam. After perusing the records, we are of the view that the matter would call for full length hearing. Such issue rule returnable in 6 weeks. Since the parties are already represented, no further notice is required to be sent in this case. Register to list the matter along with the LCR for hearing in usual course. Interim order passed.
Item 11.
May I please? Page 72, the opinion starting from page 72, my lord. Yes. My lord, I'd like to take you to page number 73, paragraph 1, my lord.
Heard Mr. Swans, learned counsel for the
Yes, Tapadar, my lord.
yes, the president and counsel for the petition. Also heard so and so appearing for the respondent. Peruse the LCR.
Please, my lord.
We are of the view that the matter would require formal hearing as such issue rule, so and so rest will be same interim order to continue.
Item 12. Issue.
May I please?
My lord,
In the present case, my lord, the inquiry report says the petitioner is a citizen of India. And reference also, my lord, recommended the same. She does not appear to
Mr.
be
Hemu Mandal, counsel for the rest will be same interim order to continue. Issue.
obliged.
For order item 13.
Yes.
In this case, Miller, I was not allowed to go on Miller interim bail. But at the time, Miller, it was granted Miller, she was suffering from illness, Miller. So Miller, she could not appear with the IO.
You came with a similar petition 2 days back.
No, earlier I filed similar petition earlier on another act. That is for extension of some time, Miller.
Yes. Yes, any objection?
I just have a listen, I don't have a problem.
For some time, or 10 days, Miller, I will appear and I will obtain bail, Miller.
We have no objection, but she should appear. This order is of May lordship.
Yes, then I.
We'll grant her
Within
10
days.
days time from today.
My
Yes,
lord.
lordship.
Mr. A. Rashid, learned counsel appearing for the applicant, also heard Ms. A. Verma, learned SC, Home Department, Government of Assam. Mr. A. Ali, learned standing counsel ECI, Mr. S. H. Hazarika, learned G. Assam, and Ms. S. Borwa, learned CGC appearing for the opposite parties. Full stop. The applicant hearing as writ petitioner has approached this court by filing WPC number 7358/2017, assailing the opinion rendered against her by the learned Foreigners Tribunal, Barpeta, 10th, Bajali, Patshala, in connection with FT case number 37/2016. By the order dated 10/5/2020, this court, while issuing rule in the writ petition, had granted some interim protection to the writ petitioner. Subject to her appearance before the Superintendent of Police, bracket border, bracket close, Bazali, honor before 30/5/2024. Mr. Rashid submits that due to a communication gap. What is the reason why she could not appear?
She was suffering illness.
Due to
I have seen given medical.
some serious illness suffered by the applicant, so great petitioner. She could not appear before the SP bracket border bracket close Bazali by 30/5/2024. As such, this application has been filed with a prayer to extend the time for appearance before the SP bracket border Bazali. Full stop. Miss so-and-so, Mr. So-and-so, Learned Council so-and-so submit that they do not have any instruction to file objection opposing the prayer made in the IA. Full stop. In view of the above and considering the ground cited by the applicant's counsel, we are inclined to allow the prayer made in the IA. Full stop. As such, next paragraph. The writ petitioner stroke applicant, or rather applicant stroke writ petitioner, is granted time till 8/7/2024 to appear before the SP border Bazali in terms of the order dated 10/5/2024. Full stop. The order dated 10/5/2024 stands modified to the above extent. Remaining part of the order dated 10/5/24 shall remain unaltered. With the above observation, the IA stands dismissed.
Pending matter item 7.
May I please, Your Lordship? Your Lordship, may I please to peruse the last order dated 22/5/2024.
What is this case? FT matter?
Here is the case, Lordships. Initially, a reference was made before the Foreigners Tribunal. The petitioner is not a Djibouti, he is an Indian citizen. But Learned Tribunal did not satisfied about the findings of the referral authority and again referred back to the It was challenged before this whole court. This whole court set aside the order of this tribunal. Thereafter, I submitted a representation before the consulate to remove the D from the brutal list, but they have not taken any steps in this regard. Hence, the present petitions, Lordship, and I am before the Lordship.
Petitioner is a declared foreigner.
No,
Then
petition reference was made. There is a debuter was inserted against his name, Lordship. In the year 1985, first his name appeared in the brutal list. He had cast vote till 2005. In the 2005, a D was inserted against his name. Accordingly, matter was inquired into by the Superintendent of Police and found that petitioner is not a D voter, he is an Indian citizen. And matter was referred to the Foreigners Tribunal. And findings is that the matter proceeding may be dropped since he is an Indian citizen. But the tribunal did not
whose
say this.
finding? Whose finding is that?
Findings of the Superintendent of Inquiry Officer, Lordship. Your Lordship may kindly be peruse the order dated 43. Then Tribunal's order. Tribunals demanded back the matter again to the authority. Page 43, Lordship.
Page 43.
43.
Hmm. What the tribunal says is not agreeing with the.
Agree. It was challenged before this all court that page 45, Lordship.
Hmm.
Order dated 2/8/2021, paragraph 5, 6, 7, 8, 11, 12, 13.
So rejection of the prayer was held to be not correct.
Not correct.
Then what happened?
Then I submitted application to remove the D from the brutal list, but the authority did not take any step. Hence, I am before this all court, Lordship. The representation submitted by referring the cases.
Hmm. So, Mr. Pine,
Well,
what is this? It seems the division bench has observed that the
yes.
proceedings ought to be dropped.
My lord, my learned friend may take my lord, instruction on the representation dated 23rd August 20. Because
In phase 53, annexure 16, page 53, annexure 16, the petitioner has filed a representation before the electoral registration officer 7, Goripur LAC honor. If I may be given some time, I'll obtain the instruction.
Time you will get, but
Because,
we want to, otherwise we'll draw contempt against this. order.
because his D may be removed as of now. That's just what I'm.
That's not the point. Has the reference case been closed?
yes,
Has it been closed?
it is closed as per my lord this because my lord the
Is
but-
the reference case closed?
Lordships.
Then what remains in this case?
D is not removing from the brutal list.
probably my lord whether it is closed or not because whether they have submitted before this before the tribunal and approached before the tribunal or not, it is not known, my lord.
Because the order for
Order
just closing the reference honor, that has not been annexed in the writ petition, neither it has been submitted before the electoral representation officer honor. Because
No, Lordship, that is closed as well. Instruction was submitted. Case referee is also made. High Court's order is also.
What is the next
Dated,
date
Lord.
fixed in the reference case, Mr.? Mr. Barbuya, what is the?
Yes, reference case page 36, Lordships.
Oh,
Enquiry report, Lordship, but reference order is not, I have not, Lordship, and I do not have. And original page 37, Lordship, or not, I have also type copy.
Take on heard Mr. F. Borvela, counsel for the petitioner, also heard Mr. J. Payang Lam, SC, Home Department, Government of Assam, bracket FT. Bracket goes Mr. A. Ali, learned SC, ECI, Mr. S. H. Hazarika, learned G. Assam, and Ms. C. Borwa, S. Borwa, learned CGC, appearing for the official respondents in this case. Full stop. It appears that pursuant to the judgment and order dated 2/8/2021 passed by the division bench in WPC number 716/2021. The reference case pending against the petitioner before the Foreigners Tribunal at Foreigners Tribunal 6th at Dhubri, Bilasipara, came to an end. However, the petitioner was also aggrieved due to the fact that his name appeared in the devoters list, and despite the representation dated 21/12/2023 submitted before the electoral registration officer Dhubri, Assam, with a request to remove the devoter tag from the petitioner, no action has been taken in the matter. Mr. Borbia submits that the authorities have themselves found that the petitioner is an Indian citizen. Stop. Notwithstanding the same, no action has been taken in the matter till today. Full stop. Mr. A. Ali, learned SCECI, prays for 4 weeks time to verify and appraise this court as to what action has been taken on the representation dated 21/12/2023 submitted by the petitioner. Prayer allowed. Is this case again after 4 weeks registered to also verify as to whether this matter before appropriate bench.
Obliged.